Hi, Attorney Steve, we're back, and this is part 2 of Arizona injunction process. This is Arizona Rule 65. This is the Attorney Steve Business and Real Estate Whiteboard, and this is general legal information, trying to help you understand what it means to get an injunction, what are the steps that you do when you're seeking an injunction. If you missed part 1, go back and see it. It's on YouTube. We throw them out there for general information. Part 2. Let's get going here, okay? So back to the Attorney Steve Real Estate and Business Whiteboard. We were talking in the last video about the different types of papers that you're going to file once you realize you need to enjoin. You've got your parties that you want to enjoin. You know what you want to enjoin. And we talked about filing papers. We talked about an application to the court. You need to prepare an application to the court. You need to prepare an order to show cause. The order to show cause is to basically set up the hearing for the preliminary injunction. If you remember the last video, we talked about an injunction basically being a two-step process. One is getting the TRO, which stands for temporary restraining order. That's good for 10 days unless a judge extends it further. And the second step is getting the preliminary injunction. Okay, that's where you basically enjoin whatever action is you're trying to enjoin. Let's say foreclosure, for example. You're trying to stop a foreclosure. You would enjoin it until the end of the case, the end of the proceeding. So that could be very important to lock up the asset in litigation so that it doesn't get transferred and now you've got some other party and this and that, and now it's all over the place. So an injunction can be a very, very important tool in the litigator's toolbox, okay? So you're going to want your application, your order to show cause. You're going to want your affidavit. You're going to want to have your plaintiff give a good affidavit as to the facts and to basically personally testify as to the authenticity of any exhibits that you might have. And you may also need requests for judicial notice. Now, I believe we've talked about request for judicial notice in another video. It's the subject of a whole separate video. But request for judicial notice is asking the court to consider something as evidence. Not just an exhibit that may be something the judge looks at, but actual evidence where the judge can say, you know, things that are beyond dispute. Okay, like here's the chain of title. Like you may want to get a certified chain of title and ask the judge to take judicial notice of that. Okay, so that's one area where you may have that. So there's hundreds of others of things that you can ask the court to take judicial notice of. Check out my other video, Attorney Steve Judicial Notice. If I don't have it, it's coming to you shortly because we got to get that out there to you. You got to understand that. Your exhibits and your defendants, your attorney's written certification of the attempts to provide notice to the other parties. The court's going to want to know that you tried to notify the other party, that you weren't just trying to sneak behind everybody's back here, nobody knows, and then you want to come and tell your one side of the story. The judge knows there's two sides to the story. He or she's going to expect that you're giving notice or trying to give notice to the other party. So the written notice of declaration, that's the attorney's notice. And if you don't have an attorney or improper, you're still going to need to give some sort of declaration or affidavit that you tried to give notice, state what you did so that the judge can feel a little more comfortable in granting your request, okay? Judge will set the date. Oftentimes in Maricopa County, you're going to want to check with your judge, your court, your clerk, find out what days do you hear these hearings, what days do you have ex parte TROs, TRO standing for temporary restraining order, what days do you hear those? And the judge will normally give you a date. You're going to provide written notice. Remember, everything you do in law, you're going to provide written notice to all the other parties so everybody knows what's going on. You're going to use your proof of service on your notice, right? So that the court knows under penalty of perjury that you tried to serve people, okay? We'll talk about proofs of service in another video, but let's get back to it. So, and then you're going to have your hearing, okay? You're going to have your hearing on your TRO. At your hearing, that's when you're going to present your evidence. You're going to present your case. If you gave notice to the other parties, it's possible they could appear. We've had them appear in person. We've had people appear by court call. We've had it where nobody appears, okay, where they're sort of content in letting you get the 10-day, and they're going to fight you here when you get to the preliminary injunction process, okay? So you want to just bear that in mind. At the hearing, again, it's typical courtroom etiquette. You want to show up on time, you want to be there, you want to be prepared, you want to have copies of everything, you want to be ready to roll, okay? So in the hearing, the judge is going to have the discretion. The judge is going to have the discretion to grant or deny the relief that you're requesting. The standard on that would be an abuse of discretion, clearly erroneous standard if you want to appeal. If the judge for some reason you think is wrong, clearly erroneous as to law, fact, so forth and so on. But keep in mind, you're also going to have a proposed TRO order. You're going to want to have a proposed order ready for the judge. Now, he or she may not use your order, but you're going to want to have a proposed order. There's basically two different types. I should put this finger down. There's basically two different types of relief that you can seek in a TRO or a preliminary injunction hearing. One is what they call negative relief, a negative injunction. And negative injunction means you're asking the court to stop one of these parties. Remember, we talked about the parties, to stop one of them from doing something, like don't let them foreclose. Okay, that's what you're trying to do. Your second form of relief is mandatory relief. That's where the court has the power to order somebody to do something. So negative is telling them not to do it. Mandatory is saying, go ahead and do this. In other words, for example, specific performance in real estate contracts, specific performance of a contract, okay? And that's another video that we'll talk about the elements of specific performance for my real estate fans out there. Okay, so that is your type of relief sought. You have your hearing. And at the hearing, assume the court's going to grant your TRO, because I'm assuming you've got good grounds. Remember, you always have to have good grounds to bring these actions. And then the court is going to set a preliminary injunction hearing. For that hearing, you're going to have an opposition for the most part. Lots of times they're going to oppose you and say that they're allowed to do what it is you're trying to stop them from doing. And you're going to have an opportunity to reply with a reply brief on that. Okay? And there's going to be a hearing on that. So this is usually where the big battle is fought. Not to say that the TRO stage is not a big battle, it is. But the preliminary injunction, that's where you're going to try to enjoin the action that you want to stop, the action that you're going to clearly set forth in your proposed TRO order. You're going to be very clear about what you want to stop, and you're going to be very clear about who you want to stop in your proposed order, okay? So don't miss that relief. Don't miss being specific as to what you're looking for, okay? Then you're going to have the hearing on that. If the judge grants your preliminary injunction, you're going to celebrate, you're going to be happy. That's under Rule 65E. The judge is probably going to require a security bond, a posting of a bond to cover the other party in the event of any losses or damages sustained for a wrongful injunction. So if they wrongfully enjoined it, then they're going to have a bond that they can recover on. So as a party seeking this, I never bring it up, and I usually leave it up to the other party. If they don't say anything and judge doesn't say anything, hey, maybe you can skate by without it. But bear that in mind, you may have to post a bond. Finally, you've got your orders granting injunction under ARS 12-210, excuse me, one more time, ARS 12-2101 F2, Frank 2, order granting injunctions immediately appealable if you need to appeal that. Disobeying a injunction, any of these parties, court can issue an order to show cause, holding the other party in contempt. Contempt equals what? Possibly jail time. And you have, after injunctions are issued, you have a possibility for a motion to dissolve or modify the injunction, saying there's not good grounds or it's overly broad. The other party can seek a motion at any time for that. So that's it. Arizona injunction process. I'm Attorney Steve. If you need a good business and real estate lawyer to help you through your issues, give us a call. We're happy to help out. 877-276-5084. Or you can find me on the web at attorneysteve.net, attorneysteve.net. Thank you, and we look forward to working with you. Have a great day.